Hello, I'm Tennessee's Comptroller, Justin P. Wilson.
And I'm Deputy Comptroller Jason Mumpower.
All Tennesseans have a right to be informed. One of Governor Lee's first actions was to sign an executive order mandating openness, transparency, and accountability in state government. We are very pleased to partner with the Governor's office in providing you some brief training on Tennessee's Public Records Act.
Over the years, the Tennessee General Assembly has passed hundreds of bills dealing with public records and open meetings. These are important issues, and it is our duty as state employees to make sure we're following the law. The Comptroller's office includes the Office of Open Records Counsel, led by Lee Pope. He is pleased to lead this training and answer any questions you might have in the future.
Thank you for your attention to this training and your commitment to transparency.
Hi, I'm Lee Pope, Open Records Counsel in the Office of Open Records Counsel in the Tennessee Comptroller of the Treasury's office. Our office provides guidance and advice to public officials and citizens across the state on Tennessee's public records and open meetings laws, also known as the state's Sunshine Laws. Today, as part of the Governor's initiative to promote transparency in state government, we would like to briefly discuss the requirements of these laws and how they might impact you as a state employee. So, how does the Public Records Act provide for transparency? Well, the Public Records Act was passed as a symbol of transparency and is provided by the Tennessee Supreme Court. Facilitating access to government records promotes public awareness and knowledge of government actions and encourages government officials and agencies to remain accountable to the citizens of Tennessee. Now, while the Public Records Act may hold us accountable, it also provides an excellent opportunity to demonstrate the great work being performed by you as employees of the state of Tennessee. So, how does the Public Records Act provide for this transparency? Well, it requires that records custodians promptly make public records available to Tennessee citizens unless otherwise provided by state law. We like to say this creates a presumption of openness. That is, in Tennessee, all public records are presumed open for public inspection unless a state law specifically makes those records or information within those records confidential. So you might be asking, Lee, who are these records custodians that must provide prompt access to public records? Well, records custodians defined under the Public Records Act as any office, official, or employee of a government entity that is lawfully responsible for the custody and care of a public record. We often like to think of records custodians as clerks or elected officials, say a register of deeds, a county clerk, maybe a court clerk, people that have a legal responsibility for keeping certain types of records. However, the definition includes any employee responsible for public records, and that would include you and the records you're responsible for in your capacity as a state employee. So be aware, your agency may call upon you to produce public records in response to a public records request. So, what is a public record? What records is the state obligated to produce under the Public Records Act? Well, public records is defined very broadly under the Public Records Act. It includes almost any type of record you can think of, regardless of physical forms or characteristics, that is either one, made pursuant to law or ordinance, or two, as part of the official transaction of government business. If either one of those applies, then you have a public record that is subject to the Public Records Act. Some common public records we see are government correspondence, things like emails, text messages, even Twitter tweets and social media posts are public record when they are related to the transaction of official government business. Video recordings, audio recordings, those are also public record. Personnel records, human resources records, things like your travel and leave information, those are also public record subject to the Public Records Act. Often citizens want to know about financial records. They want to know how government funds are being spent. Government contracts and procurement information, meeting agendas, minutes, and packets are other examples of public records subject to disclosure under the Public Records Act. Some important things to note about public record. First, A public record does not include the device that created the record. So a Tennessee citizen or another requester is not entitled to come into your office and access your work computer to search for public records. Usually, a public record must be extracted from the device and is provided to a requester in either electronic or paper form. Another important thing to note is that whether a record is created on a government-issued device does not matter. For example, I could send an email from my government-issued email account that has nothing to do with the transaction of official government business. Maybe I'm emailing a coworker about their child's birthday party this weekend. That does not relate to the transaction of official government business, and it would not be a public record, even if it's sent from my government-issued email account. Likewise, I could send a text message from my personal cell phone to a coworker. If that text message relates to the transaction of official government business, say I'm texting about a meeting tomorrow, well, that would be a public record, even though it's created on my own personal device. So be aware, whether a record is created on a personal device or a government-issued device does not matter. What matters is whether it was made pursuant to law or ordinance or in connection with the transaction of official government business. Also, I should note, public record does include draft documents. So, let's say you're taking notes right now. You are creating public record. So, what records are not subject to disclosure? There's really two scenarios. As we just discussed, you might have a record that is not technically a public record, wasn't made or received pursuant to law or ordinance, and it's not connected to the transaction of official government business. It's not a public record. More often what we see is you have a public record, but a state law makes that record or information within the record confidential. We like to call these exceptions because these state laws accept these public records from the general presumption of openness that we discussed earlier. There's at least 600 state laws that make records or information within records confidential. Some of these common exceptions we come across are things like public employee personal information is confidential, such as social security number, tax ID number, your financial account number, or other information that could lead to identity theft. Your state employee performance evaluations, those are made confidential by state law. Other records, such as records related to criminal proceedings, TBI investigations, certain juvenile records, certain medical records and information, and proprietary information, certain trade secrets are also confidential under state law. Now, these exceptions are not universal, and they can be difficult to apply. So, if you come across a situation where you're not sure whether or not a record is confidential, be sure to contact your supervisor or your legal department, because state agencies have an obligation to maintain the confidentiality of records that are made confidential under state law. Also, the improper disclosure of certain records can carry criminal penalties. So be sure to consult your supervisor or your legal department if you have a question about whether you can disclose a public record. So what do you do if you have a public records request? Well, every state agency in Tennessee is required to have a public records rule. This rule sets forth the process for making requests, including any required forms, the process for responding to requests, the statement of fees and billing and payment procedures, as well as the contact information for the Public Records Request Coordinator. Now you might be asking yourself, who is this Public Records Request Coordinator? This is the person within your agency that's responsible for routing requests to the appropriate records custodian and ensuring requests are responded to in accordance with the Public Records Act. Now, as I mentioned before, your state agency is required to promptly produce public records. If they're unable to promptly produce those records, they have to take certain action within 7 business days. So time is of the essence. If you get a public records request, be sure to contact your supervisor so they can ensure that request gets to your Public Records Request Coordinator and that that request is handled in accordance with your agency's public records rule. Now that we've covered the Public Records Act, let's move on to the Tennessee Open Meetings Act. Tennessee Open Meetings Act provides that the formation of public policy and decisions is public business and shall not be conducted in secret. So, the Open Meetings Act provides for this transparency that by requiring that all meetings of a governing body must be open to the public. As with the Public Records Act, it's construed broadly in favor of public access. Also, it's worth noting the Open Meetings Act grants people the right to attend meetings, but not the right to speak or otherwise participate at these meetings. So as I mentioned before, the Tennessee Open Meetings Act requires that all meetings of a governing body must be open to the public. So what is a meeting of a governing body? Well, this is generally defined as the convening of two or more members of a public body to discuss or deliberate public business that a majority of the public body would need to vote upon to make a final decision. Note, a meeting under the Open Meetings Act does not occur if members of the governing body do not discuss or deliberate public business. So you may have an informational session or an executive session with a board attorney where the members do not discuss public business. That would not be a meeting subject to the Open Meetings Act. So, let's say you do have a meeting subject to the Open Meetings Act. What are the requirements of the Open Meetings Act? Well, they're fairly quite simple. The Open Meetings Act requires that the meeting must be open to the public, the governing body must provide adequate public notice of the meeting, which is generally notice that fairly informs the public of the time and place of the meeting so they can exercise their right to attend. The Open Meetings Act also requires meeting minutes. At a minimum, these minutes must include the persons present, motions, proposals, and resolutions offered, and the result of any votes taken. Lastly, the Open Meetings Act prescribes secret voting. You cannot have secret votes at a public meeting. But that's generally the requirements of the Open Meetings Act if you have a meeting of a governing body. Thank you for taking the time to learn a little bit more about the Public Records Act and the Open Meetings Act. We're happy to provide this information as part of the Governor's initiative to promote transparency in Tennessee government. If you have any questions about these laws, feel free to contact our office, the following contact information. Thank you.
We hope you've enjoyed this training on public records and open meetings in Tennessee. We appreciate the time you've taken to watch it.
Thank you for your commitment to transparency and to the citizens of Tennessee.